Good evening, friends. This is the order given in Notice of Motion number 548 of 2019, which was heard on 4th of this month. The order was uploaded on the afternoon of the 5th. I personally consider it a very good order, although part of the order has been has allowed the deletion, or rather ordered the deletion of videos, directed the deletion of videos. Still, I consider it a very good order because it has taken cognizance of the fundamental rights issues and also some other basic issues that I have raised, and it has taken cognizance of the fact that I did not give consent for the videos to be deleted in the very first hearing. So I am going to read just the operative part of this order by Justice Gupte. Now, the suit was, okay, I'm going to read the first paragraph. The present suit has been filed by the plaintiff complainant complaining of the publication of defamatory material against the plaintiff by the original defendants and seeking inter alia a perpetual injunction against such publication. The alleged defamatory material concerns flats sold by plaintiff to defendant number 2 and 3. The defendants had inter alia claimed in the subject publication that plaintiff has used defective and impermissible building material in these flats. Now, there is a lot of detail in this. I will skip the details and go to the main part. I'm going to post a copy of this, a link to this order in the description below, and you guys can take a look at it. Now, it explains the history because this notice of motion was filed after a number of other notices of motion. And I'm skipping to point number 5. At the hearing of this notice of motion, defendant number 1, who appeared in person, that's myself, stated before the court that his advocate's consent recorded in the first interim order passed on 21st January 2019 was not on his instructions. He submitted that he had in fact tried to protest when the advocate gave consent on his behalf, but he was brushed aside. Defendant number 1, however, stated before the court that he would not henceforth, during the pendency of the original notice of motion, that is 152 of 2019, make any statement in his YouTube channel concerning the defects in the flats agreed to be sold by the plaintiff to defendant number 2 or 3, or the conduct of the court proceedings so far or thereafter. He also submitted. So basically, I had made a commitment to Justice Gupte on this count. You can read paragraph 5. And the court in the premises directed respondent number 4, YouTube, to forthwith delete material from C to J and K to Q, etc., etc. Now, the court was of the view that the hearing of the notice of motion number 152 should be taken up expeditiously, and defendant number 1 should be allowed to participate in the hearing and ordered accordingly by a clarificatory order passed on 5th February 2019. URLs of the videos directed to be taken off were listed for appropriate action by YouTube. Now, a lot of the background is stated by this order, and the main part is that the videos in this table, which is exhibit QQ of the notice of motion, which I have also uploaded earlier. Exhibit QQ, the videos mentioned in exhibit QQ, there are 17 videos, were directed to be deleted by me and or YouTube. Now, I am saying and or because YouTube has the power to be able to block it in India, which is where the jurisdiction of Bombay High Court lies. And one of the arguments that I made was that there was no jurisdiction to order deletion worldwide, and so the plaintiff had wrongly invoked the jurisdiction of Bombay High Court, trying to get YouTube to delete it worldwide. Now, YouTube had already blocked these URLs which I mentioned from my channel, from the main channel. What I had done subsequently, what had happened subsequently was another person named Murli Iyer living in the US had uploaded on this channel, Mirror Mirror, on his channel, okay, where if you search Mirror Mirror on the wall and such other things, you could find many of these videos, but not all. Many of these videos had been uploaded. 1, 2, 3, 4, 5, 6 of these videos which had been brought down had been uploaded, among other videos. Afterwards, what I had done was I had uploaded on another YouTube channel of mine, which is called Krish the Dragon Slayer, blocked videos of Loda. Now, on this channel, I had uploaded this bunch of the same thing that had been brought down. I had uploaded it again. Bombay High Court ordered that these should be brought down, and accordingly, I have put all of these into private mode. All of these means the ones in Krish the Dragon Slayer, the 17 videos mentioned in this table, I have put it into private mode. Therefore, they will not be visible to anybody. They will not be accessible to anybody. There are, of course, other videos on Krish the Dragon Slayer. I think there will be 23 other videos which had earlier been deleted by YouTube, or rather blocked by YouTube for reasons best known to them. And those are still accessible on Krish the Dragon Slayer. The same 17 videos which were there in the original channel, Krishnaraj Rao, are now going to be means they had already been blocked for viewing in India. So they will continue being blocked for viewing in India. That situation continues. As for what happens with Murli Iyer's channel and the videos, I am not aware. We can click on one and see if it is accessible, and you can see that Murli Iyer's video has been, this thing has been brought down, video unavailable. Right now, and I will also show you this one, the ones that I have. This is Krish the Dragon Slayer. I'm just clicking on a random video of Krish the Dragon Slayer, and you will also get this message: this video is unavailable. Okay, and if you are in India, then I'm going to give you another sample. This is from my original krish.kk photo, or let me take this other sample just for showing you that it is basically applying to all the different videos. So I'm copying, pasting this here where I am not signed in as krish.kk photo, because the other one will of course show it. Now here I am not signed in, and again you can see video is unavailable, which means basically that the court's order has taken effect on this entire batch of videos, all these videos. Okay, I'm giving you one more sample from Murli Iyer, and you can see that I'm copy pasting a Murli Iyer video URL, and hey, wait a minute, how did this happen? Mirror Mirror on the wall, Bombay High Court defendant. Wait a minute. So this one has not yet been blocked on Murli Iyer's channel. Now this is something I cannot do. Okay, this, let us see now. Some of these videos cannot be blocked on Murli Iyer's channel. I don't know. How does this work? Let me see. I'm going to copy another one. Obviously, it is not my channel, so I can't delete anything here. Boom. This is unavailable. So that one is a fluke, I guess. Otherwise, all the videos have been blocked. So the videos in this table basically have been blocked. And I have complied and YouTube has complied. Now let us come to the part where the court has taken cognizance of my points. It says, coming now to the other two categories of material referred to by learned counsel for the plaintiff, which is claimed to be in breach of the order passed by this court on 21st January 2019 and 23rd January 2019. It is to be noted that the court has not applied its mind as to whether or not this material was in fact defamatory as claimed by the plaintiff. The order of 21st January 2019 was passed expressly on consent of parties. It was, in other words, on a concession made inter alia by defendant number 1 that he would remove the material from the net. Since it is asserted by defendant number 1 that consent was unauthorizedly given on his behalf, and as a result he has now disengaged his advocate. My advocate and I parted ways the very same day, within 12 hours of this happening, and has been making submissions. So defendant number 1, that's me, have been making submissions in person. The matter needs to be heard on merits, not just from the point of view of asserting whether or not the material is in breach of the original consent order of 21st January 2019, on which the order of 23rd January 2019 is based, but whether it is in fact defamatory and calls for its removal on that basis. So, whether the videos that I have published, which were ordered to be removed on 21st and 23rd January, are defamatory and they have to be removed on that basis. Now, as the court indicated on the last occasion, since the main notice of motion itself is to be heard shortly, the court would not like at this stage to go over the material to assess the prima facie merits of the plaintiff's case for defamation based on this material. That exercise, anyway, is to be taken up shortly. The parties have either filed or are in the process of filing of their detailed pleadings in this behalf, and the motion is coming up for hearing on 20th March 2019. Defendant number 1 has raised several issues in his submissions, reflecting not only on the merits of the plaintiff's case. Now, this is, I feel, the most important part, vindicating. So there are two parts of this order which vindicate my stand. Defendant number 1 has raised several issues in his submission, reflecting not only on merits of the plaintiff's case of defamation, but on fundamental issues of freedom of expression and public interest. The decision on all these matters may be appropriately deferred till that date, that is 20th March 2019. So this is one thing that they are considering. And the second thing that they have considered my my submissions is that the order of 21st Jan and 23rd Jan were based on my consent, my supposed consent. Now, since I did not give consent and since my consent was unauthorizedly given on my behalf, and now that advocate has been disengaged by me, or rather we sort of mutually parted ways, because after I made those videos and after I had I had some strong words with this advocate, we just parted ways. Okay, he said he would not represent me, and I had also, of course, never persuaded him to represent me. because of what he did. So anyway, so these points have been taken into consideration, and for that reason, a lot of the videos that they sought deletion of, the court did not pass. However, the court also mentions, and this is a fairly sobering kind of a note. At the same time, it needs to be asserted that no person can be allowed to breach an order passed by the court or an undertaking given to the court, and at the same time pursue the matter on merits without remedying such breach. His defense on merits is likely to be struck off, or he may not be heard. No one can be allowed to avail of due process of law without submitting to it, and honoring court orders and undertakings given to the court is very much part, or rather the essence of submitting to due process. Now this part is like a fairly strong warning where I am concerned. So we will now have to see how it goes forward. And the order was that pending the hearing and final disposal of the notice of motion herein, defendant number 1 and YouTube are directed to forthwith remove, block or disable links to the videos. Exhibit QQ. Okay, so QQ, the compliance with the entire thing has been done, and where compliance now, and then pending the hearing and final disposal of notice of motion, defendant and your respondent YouTube are directed to forthwith remove, disable links to the videos. Now the videos means they are referring to the videos, the 17 videos in the above table. That's what I understand. And the court has given these three categories. One is mirror mirror on the wall, which is Murli Iyer's channel. Another is just for kicks being human, also Murli Iyer's channel. Okay, and the third is Krish the Dragon Slayer. This is my channel, and from my channel I have disabled and removed 17 of the videos which are mentioned in table number 3, not table number 3, the above table in the order. So I think compliance is complete from my side, and however, YouTube has called for a hearing tomorrow morning to clarify on this part of the order. I think there is some doubt about this part of the order and the compliance. Now, pending the hearing and final disposal of the notice of motion, defendant number 1, that's me, is restrained from republishing or re-uploading or repeating in print the material forming the videos described in Exhibit QQ in the plaintiff's exhibit affidavit dated 26th, which is the same, all those tables, in support of the notice of motion and set out in paragraph 7 above, or the URLs described in clause 2 above. So, as if and so long as defendant number 1 does not take steps to comply with the present order or acts in breach thereof, he shall not be permitted to rely on his pleadings or make any submissions in the main notice of motion, that is notice of motion number 152 of 2019. So if I do not comply with this order, I will not be able to rely on my pleadings, which I have already made, or make any submissions in the main notice of motion number 152 of 2019. This is a fairly critical kind of thing because that's the very first notice of motion. So in the meanwhile, the acts of defendant number 2 complained of in the affidavit dated 26 January 2019 in support of his present notice of motion may be considered and claimed as acts of aggravated contempt for the purpose of the contempt notice served against him 23rd January 2019 and made returnable on 19th March. So before on 20th the main case will be heard, or rather than the main suit will be heard. Notice of motion number 152 of 2019 and the main suit. On 19th there will be a separate hearing concerning my contempt, and that will also include some of these points. The present notice of motion shall be heard along with notice of motion number 180 of 2019 and contempt notice. So, notice of motion 152 of 2019 shall be heard separately on 20th March 2019 at 3 p.m. So, these are the orders passed by Justice Gupte. I sincerely believe that I have complied completely with the requirements of this order. So I feel that as far as this order is concerned, I am in the clear. And as far as the contempt notice is concerned, we will have to. I have filed my contempt notice. I am in the process of filing my reply. And 152 of 2019, I have filed my reply. And the main suit also, I have filed my reply. So we will see how it goes. I'll keep you posted. Thank you so much and good night.